On an October night in 1912, the lamps inside the Blackridge County Courthouse burned long past sunset. 12 jurors filed back into the courtroom after hours of deliberation. Farmers, shopkeepers, and the widow of the dead man leaned forward in silence as the foreman stood to speak. The clerk dipped his pen in ink, ready to record the decision that would define a life: guilty or not guilty. The trial had consumed the town for months. Testimony had been heard. Arguments had been made. The law had run its course. And then, somehow, it didn't. Because when historians opened the docket decades later, they found the page where the verdict should have been blank. No conviction, no acquittal, no mistrial. The trial had ended. The jury had returned. But the official record never tells us what they decided. Official court indexes confirm that State v. William H. Carter concluded on October 18, 1912, in Blackridge, Kansas. The docket lists the charges, the witnesses, and the date the jury retired to deliberate. Newspaper summaries verify that closing arguments were delivered and that townspeople crowded the gallery awaiting the outcome. Everything about the proceeding follows the expected rhythm of early 20th century criminal trials, up to the final entry. Where the clerk should have recorded the verdict and the judge's signature, there is only unfinished space. The case is marked concluded, but nowhere does it say how. In 1912, Blackridge, Kansas was the kind of town that believed in order. It sat along a modest rail spur that cut through miles of wheat fields, its grain elevators rising above the prairie like watchtowers. On clear days, the wind carried the smell of chaff and livestock through the streets. Main Street was unpaved but busy. Wagons creaked past the general store. Boys ran errands between the barber and the post office, and men gathered outside the hardware shop to trade weather predictions and land rumors. At the center of it all stood the Blackridge County Courthouse. Built in 1889 from locally fired red brick, the structure was both practical and symbolic. A square clock tower rose above its entrance, though the clock itself was known for losing minutes unpredictably. White limestone trim framed tall arched windows that allowed sharp prairie light to spill into the upstairs courtroom. On windy days, the glass rattled faintly in its frames. The first floor housed administrative offices, the clerk's room, a vault for deeds and probate files, and a narrow corridor that smelled faintly of paper and oil. The second floor was reserved for the courtroom. A wooden staircase, worn smooth at the center of each step, led upward to double doors that opened into a chamber designed to command attention. Inside, the room felt larger than the town that surrounded it. Long oak benches faced a raised judicial platform. Behind the judge's desk hung a painted state seal, slightly tilted from years of vibration caused by windstorms. To the right stood the jury box, 12 straight-backed chairs enclosed by a waist-high railing. The witness stand occupied the left side, positioned so that anyone speaking faced both judge and jury directly. The building had seen disputes before: land boundaries, cattle theft, unpaid debts, but rarely had it hosted a trial as serious as the one that unfolded in October 1912. Blackridge itself was not immune to tension. Beneath its orderly surface ran quiet rivalries. Land meant survival. Water rights meant profit. Fence lines were not merely wooden boundaries, they defined futures. Neighbors could be allies one season and adversaries the next. Thomas Bell's farm bordered that of William Carter on the eastern edge of town. Their properties met along a strip of creek-fed soil considered unusually fertile. Over the years, minor disagreements over survey lines had been recorded at the county office. Nothing violent, nothing extraordinary, just the ordinary friction of rural life. Until March of that year. When Thomas Bell was found dead in his field, the calm identity of Blackridge shifted. The discovery occurred just beyond the visible range of the courthouse tower, in a stretch of land open enough that gunshots could travel, but isolated enough that no one admitted to hearing one. Word spread quickly, moving faster than the afternoon train. By dusk, the town square was thick with speculation. The courthouse became more than a building that season. It became a stage for collective judgment. Throughout the summer and into autumn, its upper windows glowed during preliminary hearings. Farmers who had once rushed home before dark lingered in the square discussing testimony. Women who rarely entered the courtroom climbed the staircase to observe proceedings. Attendance was not mandatory, but curiosity was irresistible. The physical setting amplified the drama. When the wind pressed against the courthouse walls, the sound echoed faintly inside, like distant breath. The wooden floors creaked beneath shifting jurors. Sunlight moved slowly throughout the room during testimony, stretching shadows behind the defense table. Everything about the space suggested permanence: brick, oak, limestone. It was meant to record, to preserve, to hold events firmly in place through ink and ledger. And yet, in this building constructed to document truth, something would occur that defied the very purpose of its walls. The town trusted that whatever happened inside that courtroom would be written down, signed, and sealed into history. They did not yet know that the most important line would never be recorded. If the courthouse represented authority in brick and stone, the records represented it in ink. In 1912, Blackridge County maintained its legal history in large, leather-bound docket books stored in a fire-resistant vault on the courthouse's first floor. Each volume was indexed by hand. Cases were entered chronologically, assigned a number, and summarized in careful script by the clerk of court. Margins were narrow, lines were ruled in faded blue. Every entry followed a predictable rhythm: charge, arraignment date, witness list, jury selection, verdict, sentencing. The Carter trial appears in Volume 7. The entry begins without irregularity. The heading reads, State of Kansas versus William H. Carter, charge, murder in the second degree. Below that, dates are listed in steady penmanship. October 14, jury impaneled. October 15 through 17, testimony heard. Names of witnesses appear in abbreviated form: T. Bell, deceased, referenced; M. Bell, widow; J. Rollins, farmhand; E. Sutter, county surveyor. The clerk's handwriting remains consistent across pages before and after the trial, suggesting no disruption in staffing. Ink density matches surrounding entries. There is no visible tear, stain, or smudge that would indicate damage. The October 18 notation is the final detailed line. Jury retired at 3:12 p.m. for deliberation. Below it, in the same hand, jury returned to court at 9:42 p.m. And then, nothing. The remainder of the page, nearly half its length, is blank. There is no verdict rendered, no defendant acquitted, no guilty as charged, no notation of mistrial or hung jury. The following page begins abruptly with a probate filing dated November 2, 1912, unrelated to the Carter case. The clerk did not leave a note explaining an interruption. The formatting continues seamlessly as though the trial had been resolved in ordinary fashion. For historians, the absence is more striking than any damaged page would have been. Blank space in a docket book is rare. Paper was costly. Clerks were methodical. Space was used efficiently. Even dismissed cases received a final summary line. Newspaper archives complicate the matter further. The Blackridge Weekly Herald ran short daily summaries of the trial during its progression. The October 19 edition includes a paragraph stating that the jury had returned after extended deliberation.
The phrasing implies closure but offers no result. The following week's edition makes no reference to the case at all. In larger cities, trial outcomes were printed prominently. Even small-town weeklies typically declared verdicts clearly. The omission stands out not because it is dramatic, but because it is quiet. There is no evidence of fire or flood affecting that volume. County maintenance logs show no archival incident in 1912 or the years immediately following. The leather binding of Volume 7 remains intact. The paper edges are evenly yellowed with age, not torn. Further review of ancillary documents deepens the mystery. Juror compensation slips exist for the Carter case, each signed and dated October 18. The payment covers service through conclusion of proceedings. That language suggests the trial ended formally, not in postponement. Yet there is no sentencing record, no appeal filed, no incarceration log connected to Carter's name in county jail registers from late 1912. The absence extends beyond a single missing word. It stretches into every adjacent ledger. In legal systems, closure is procedural. Judges sign, clerks record, seals are affixed. Even sealed cases are marked as such. Silence in documentation typically signals loss through damage or administrative oversight, but here the silence feels deliberate. The structure of the record remains intact, only the conclusion is withheld. The docket does not appear interrupted, it appears paused, and then bypassed. In a building designed to preserve accountability, the Carter trial leaves behind a void, shaped precisely like a verdict.
To understand what may have happened inside the courtroom, it helps to look beyond it, at the two families whose names defined the case. William H. Carter arrived in Blackridge in 1897 according to county land transfer records. He purchased 40 acres along the eastern boundary of town, property considered modest but fertile due to a narrow creek that cut through its southern edge. Census data from 1900 and 1910 lists him as a farmer, born in Illinois, literate, married to Eliza Carter, with 2 children, Samuel and Ruth. Tax rolls describe him consistently as current, no delinquent payments, no prior criminal entries. His signature appears on agricultural cooperative forms and seed orders archived in local business ledgers. By all documentary accounts, Carter was steady, if unremarkable, the kind of man whose life left a quiet paper trail. Thomas Bell's records tell a different story. The Bell family had been in Blackridge since the 1880s. Thomas inherited a larger parcel of land from his father, including the acreage directly bordering Carter's property. Deeds show minor expansions over the years, suggesting prosperity. Bell's name appears frequently in civic matters, road petitions, drainage agreements, even a brief appointment as township assessor in 1909. The relationship between the two men was documented not through dramatic events, but through incremental friction. Survey maps filed in 1905 and 1908 indicate adjustments to boundary markers along the creek. A handwritten note attached to the 1908 survey references disagreement regarding fencing alignment. No legal action followed at that time, but the record suggests tension over land that may have shifted slightly due to seasonal flooding. In rural communities, such disputes could linger for years without exploding into violence. Boundaries were practical concerns, affecting grazing routes, irrigation access, and ultimately income. When Thomas Bell was found dead in March 1912, the shock was immediate, but not random. He was discovered in the early morning by a hired hand who had arrived to mend a broken gate. The official coroner's summary, still preserved, states a single gunshot wound to the chest. No signs of prolonged struggle were recorded. Suspicion fell toward Carter quickly, though the official reasoning remains unclear.
Some accounts suggest that Carter had been seen walking the fence line days before. Others point to previous arguments overheard by neighbors. Yet the formal indictment rests on circumstantial evidence, not eyewitness testimony. During the trial, according to newspaper summaries, Margaret Bell, widow, testified regarding the ongoing land dispute. She described prior arguments over creek access and accused Carter of threatening language during a heated exchange months before the shooting. The defense reportedly countered with testimony from farmhands who claimed Carter was at home repairing equipment on the morning of the death. Beyond these fragments, what remains striking is what happens after October 1912. Margaret Bell filed a civil wrongful death claim against Carter shortly after the criminal proceedings concluded. That filing exists, but 3 months later, the claim is marked withdrawn. No settlement amount is listed. No explanation accompanies the withdrawal. Meanwhile, Carter's presence in Blackridge dissolves from official documentation. A property transfer recorded in November 1912 shows his land sold to a third party at a value slightly below assessed market price. The deed contains no foreclosure language. It reads as a voluntary sale. By the time the 1920 federal census is taken, neither William nor Eliza Carter appear in Blackridge nor in surrounding counties under easily traceable spelling variations. The Bell family remains. Margaret Bell is listed as head of household in 1920. Her land holdings appear stable. No further legal filings reference the 1912 case. Two families tied together by a strip of creek-fed soil, one rooted in place, the other erased from the town's continuing story. The official record never declares Carter guilty. It never confirms him innocent. Yet the consequences, departure, land transfer, silence, suggest that whatever occurred inside that courtroom altered both households permanently. Not through a documented sentence, but through something left unwritten.
In legal proceedings, silence is rarely neutral. Courtrooms are designed to produce sound, testimony spoken aloud, objections raised, verdicts declared with formal clarity. Even when cases collapse or juries fail to agree, the record reflects that failure. Procedure demands closure, even if that closure is incomplete. But in Blackridge, after October 18, 1912, silence did not feel procedural. It felt intentional. The week following the trial, the town resumed its routines with unusual speed. The Blackridge Weekly Herald, which had devoted short columns to daily testimony, printed nothing further about the case. No editorial reflection, no public reaction. The front page returned to crop yields, rail schedules, and an upcoming church social. That absence is striking not because newspapers thrived on sensationalism, small-town papers often avoided it, but because murder trials were community-defining events. Even restrained reporting typically acknowledged outcomes. A simple sentence would have sufficed. The defendant was acquitted, or the jury returned a guilty verdict. Instead, the paper closed the subject without explanation. Town council minutes from late October show no discussion of unrest or security concerns. There is no mention of protest, disturbance, or heightened patrols. If the verdict had been controversial, it left no trace in municipal documentation. Equally unusual is the behavior of Judge Harold Whitmore. His resignation, dated December 3, 1912, cites family considerations requiring relocation. The letter is brief, 2 paragraphs, and contains no reference to the Carter trial. Judicial resignations were not unheard of, but they were typically accompanied by public acknowledgement or formal farewell in local press. Whitmore's departure receives only a short notice announcing his replacement. There is no evidence he was censured, no indication of scandal in official filings, and yet the timing invites scrutiny. Legal scholars reviewing the docket have noted that if a jury deadlocked, unable to reach a unanimous decision, the judge would declare a mistrial and record it explicitly. Retrial could then be scheduled, but there is no retrial entry, no subsequent indictment. If a private settlement influenced proceedings, it would not negate the need to enter a verdict. Criminal cases were matters of the state, not solely between families. Withdrawal of the civil suit by Margaret Bell does not legally explain the disappearance of a criminal conclusion. Oral histories collected decades later hint at discomfort rather than outrage. A 1958 interview with a longtime Blackridge resident, archived by a regional historical society, references the Carter matter as something best left in that time. The speaker does not elaborate. No interviewer pressed further. This pattern, minimal reporting, swift civic normalcy, a judge's departure, and collective reticence creates a different kind of record, not one preserved in ink, but one etched into behavior. Silence can be accidental, born of lost documents or clerical error, but sustained silence across institutions, press, court, and community suggests coordination or shared interest. What might compel such restraint? Possibilities range from the mundane to the consequential. Perhaps the jury returned a verdict so divisive that town leaders feared escalation. Perhaps new evidence emerged privately, casting doubt on both prosecution and defense. Or perhaps an agreement was reached that prioritized community stability over public clarity. None of these scenarios can be proven with surviving documentation. The absence itself becomes the subject. In most historical mysteries, we search for hidden pages, burned files, or erased signatures. In Blackridge, the paper remains intact. The ink above and below the gap is steady. The silence does not scream, it lingers. The courtroom did not close abruptly. The town did not fracture visibly. Instead, a collective decision appears to have been made, not to speak further. And sometimes, what a community refuses to repeat becomes more powerful than what it once declared aloud. For more than 60 years, the Carter case rested exactly where it had been left, in Volume 7 of the Blackridge County docket books, its final 9 trailing off into blank paper. The mystery might have remained confined to that single ledger, if not for renovations begun in the summer of 1974. The courthouse, by then weathered but still functional, required structural reinforcement. Contractors were tasked with replacing portions of the aging roof and updating electrical wiring. During the process, workers cleared accumulated debris from the attic crawlspace above the second-floor courtroom, a narrow, dusty area framed by exposed beams and layered with decades of forgotten storage. Among broken chairs, outdated ballot boxes, and rolled-up campaign banners sat a small wooden document chest. It was not unusual for old courthouses to store surplus materials in attic spaces. What was unusual was the chest's condition. Locked, relatively well preserved, and labeled faintly in pencil with a case number. The number matched the Carter trial. Inside were miscellaneous documents tied loosely with twine. Most were administrative, duplicate juror summonses, fee receipts, and handwritten notes from the clerk's office that appeared to be preliminary drafts of docket entries. These drafts corresponded to portions of the official ledger already preserved downstairs. They added no dramatic revelation, only confirmation of procedure. But at the bottom of the chest lay a folded sheet of stationery distinct from the others. The paper bore no official letterhead. It was heavier stock than typical clerk notes, and the ink appeared darker, as if written deliberately and without haste. Across the top corner was the Carter case number, written in the same format used in court documentation. The message itself was brief. Proceedings concluded upon private instruction. Entry withheld. There was no signature, no date, no seal. The phrasing is peculiar. Private instruction does not align with standard legal terminology of early 20th century Kansas procedure. Courts operated publicly. Instructions were issued from the bench, recorded and preserved. Even sealed cases were marked accordingly. The word withheld suggests choice, not accident. When county archivists examined the note, they confirmed that the handwriting did not match the primary clerk's script in Volume 7, nor did it align cleanly with known samples from Judge Whitmore's resignation letter. It remains unattributed. Equally notable is the note's location. It was not filed inside the official docket book. It was separated from formal records and placed in a container stored above the courtroom itself, physically removed from the vault where permanent documentation belonged. Why store it at all? If the intent were total erasure, destruction would have been simpler. Instead, the note was preserved but concealed. It neither clarifies the verdict nor confirms suppression explicitly. It acknowledges closure while simultaneously admitting omission. The discovery did not immediately generate public controversy. In 1974, the county treated the document as a historical curiosity rather than evidence of wrongdoing. A brief mention appeared in a regional historical newsletter describing the find as an unusual archival gap. No formal investigation followed. Legal historians who later reviewed the note have proposed cautious interpretations. Private instruction could imply a directive from a higher judicial authority, perhaps advising dismissal or negotiated resolution. It could refer to an agreement reached outside open court, though criminal law typically prohibits substituting private settlements for public verdicts. What the note undeniably confirms is awareness. Someone recognized that the final entry was intentionally left incomplete. Someone chose not to document the verdict in the official ledger, and someone believed omission warranted explanation, but only in a form hidden from the public record. The attic discovery does not reveal what the jury decided that October night. It does not exonerate Carter or condemn him. Instead, it shifts the mystery from absence to action. The blank space in Volume 7 is no longer an unexplained gap. It is the result of a decision preserved quietly above the very courtroom where the verdict should have been written. By the time the attic note surfaced in 1974, most of the individuals directly connected to the Carter trial were long gone. What remained were documents, patterns, and the structural logic of a small-town legal system. If the verdict had been withheld deliberately, the question was no longer whether it happened, but why. In early 20th century rural courts, formal procedure coexisted with informal influence. Judges were elected or politically connected. Prominent families often held civic authority through land ownership and business ties. While the law required verdicts to be entered into record, enforcement of those requirements depended on the very officials tasked with maintaining them. The Bell family's local standing is documented. Thomas Bell had served in minor township roles. His extended relatives appear repeatedly in council minutes and agricultural board listings. Influence did not require corruption. It operated through familiarity, reputation, and pressure applied quietly rather than publicly. If the jury had acquitted William Carter, especially in a case built on circumstantial evidence, the outcome could have been deeply unpopular. An acquittal might have been seen as a failure of justice, particularly by those who believed Carter guilty from the outset. Social unrest in a small farming town would not resemble riots or public protest. It would manifest as fractured trade relationships, economic retaliation, or threats to stability. Conversely, if the jury convicted Carter but later evidence cast doubt on the verdict, local officials might have faced a different crisis: the risk of wrongful execution or imprisonment under scrutiny. Appeals processes existed, but they were slow and costly. A negotiated resolution outside public view may have seemed preferable to exposing procedural weakness. The phrase private instruction complicates both possibilities. It implies direction from someone with authority, potentially the judge himself, or perhaps even a higher judicial office. Yet no correspondence survives confirming outside intervention. Judge Harold Whitmore's resignation remains one of the few tangible shifts following the trial. His departure did not generate scandal in official reports, but the timing, within weeks of the trial's conclusion, suggests that something significant occurred. Resignations for family considerations were common euphemisms in that era, used to avoid elaboration. Another factor warrants attention: the withdrawal of Margaret Bell's civil suit. Civil actions, unlike criminal prosecutions, could be settled privately. If a financial agreement was reached between the families, it might explain her decision to withdraw the claim. But such a settlement would not legally eliminate the need to record the criminal verdict, unless the criminal verdict itself was entangled in that agreement. Some legal historians have speculated that under extraordinary circumstances, a judge might have encouraged a negotiated departure, urging Carter to sell his land and leave Blackridge in exchange for a softened outcome or dismissal. While ethically questionable, informal resolutions were not unheard of in tightly bound communities seeking to preserve cohesion. If Carter agreed to leave quietly, and if the Bell family accepted that departure as sufficient closure, the public reading of a divisive verdict may have been deemed unnecessary or even dangerous. The Attic Notes language, entry withheld, does not claim destruction. It acknowledges restraint. It suggests that the verdict, whatever it was, existed in spoken form. Jurors may have delivered it. The courtroom may have heard it. But the final act of permanence, writing it into history, was consciously denied. A cover-up does not always resemble conspiracy. Sometimes it resembles consensus, a shared understanding that recording the truth would fracture more than it would heal. No surviving evidence proves corruption beyond doubt. There are no bribes documented, no signed confessions of suppression. What exists instead is convergence. A blank docket page, a hidden note, a judge's exit, a withdrawn lawsuit, and a family that vanished from town records. Individually, each detail could be explained. Together, they suggest that Blackridge chose quiet resolution over documented justice, and in doing so, transformed a verdict into a secret. When we imagine lost history, we tend to picture flames. Courthouse fires, floods swallowing archives, wars scattering documents across continents. Loss feels accidental in those images, the byproduct of disaster. But the Carter case presents something quieter, and in some ways more unsettling. Nothing burned in Blackridge. No flood erased the docket. The ink did not fade. The page remains exactly as it was left in October 1912. Structured, ruled, waiting. The absence is not destruction, it is restraint. A trial took place, witnesses swore oaths, a jury deliberated for hours. The machinery of justice moved forward with visible momentum. And then, at the final step, the moment when a spoken decision becomes permanent record, the process halted. That blank space is not merely a clerical curiosity, it represents a fracture between event and history. Something happened in that courtroom. Words were spoken. A foreman likely stood and delivered a conclusion. The defendant would have heard it. The widow would have heard it. The judge certainly did. Yet whatever was said was denied permanence. History often depends on what is written down. Without ink, even significant events dissolve into uncertainty. The Carter trial challenges the assumption that archives are neutral containers of truth. Records reflect choices, what to preserve, what to summarize, and occasionally what to omit. It is possible that the omission was pragmatic rather than malicious. Perhaps town leaders believed they were protecting stability. Perhaps they feared unrest, retaliation, or a lingering feud that would poison Blackridge for generations. In small communities, harmony can feel more urgent than transparency. But harmony achieved through silence carries its own cost. William Carter's name fades from local records after 1912. Whether he left as a guilty man spared public condemnation or as an acquitted man pushed out by suspicion, The effect is the same. His story ends without resolution. Thomas Bell's death remains formally acknowledged, yet legally unfinished. Margaret Bell withdrew her civil claim, but we do not know whether that withdrawal reflected closure or compromise. Even Judge Whitmore's departure acquires ambiguity. Was it coincidence, fatigue, or the quiet aftermath of a decision that could not comfortably be defended on paper? We are left with a courtroom that functioned, a jury that deliberated, and a ledger that stops short of completion. The Carter case reminds us that justice does not live only in verdicts. It lives in the willingness to record them, to stand by them publicly, even when they divide opinion. When a community chooses not to memorialize its most consequential decisions, it reshapes its own past. In Blackridge, the trial officially concluded. That word appears in payment logs and procedural summaries. Concluded suggests finality, but without a verdict entered, the conclusion is hollow, a door closed without anyone confirming what lay behind it. What remains is a space, a gap measured not in missing pages, but in missing words. And sometimes, those are harder to recover than ashes. Some histories aren't destroyed. They aren't forgotten. They're simply never written down. If stories like this remind you that history is more fragile and more human than we assume, consider following for more investigations into the cases that official records left unfinished. There are countless dockets, archives, and faded ledgers still holding their silence. Because sometimes the most revealing part of the story isn't what was recorded, it's what was carefully left blank.